Good afternoon and welcome to the Appellate Division, First Department. Court is now in session. I will begin with the call of the calendar. Counsel, please pay attention for the call of your case. People v. Anonymous. Appellant's counsel.
Yes, this is John Palmer for the defendant appellant.
Good afternoon. You've been granted 4-2. Respondent's counsel.
This is Daniel Young for the Office of the Bronx District Attorney.
Good afternoon, Mr. Young. You've been granted 4 minutes. Case of children submitted. People versus Elisette Jesus, counsel for appellant.
Good afternoon, Hannah Gladstein for the appellant, Ms. Jesus.
Good afternoon, Ms. Gladstein. You've been granted 4 minutes and respondents have requested no argument time.
Thank you.
Deca Immobiling versus Lexington Avenue Hotel, counsel for appellant.
Good afternoon, Your Honor. Jed Bergman for appellant.
Good afternoon, Mr. Bergman. You've been granted 5-1. Counsel for respondent.
Good afternoon, Josh Wurtzel from Schlumstone and Dolan for the respondent.
Good afternoon, Mr. Wurtzel. You've been granted 5 minutes. People versus Travell London, counsel for appellant.
I'm sorry. Good afternoon, Your Honor. Simon Greenberg for Travell London.
Good afternoon, Mr. Greenberg. You've been granted 5-2. Counsel for respondent.
Good afternoon, Your Honor. It's Michael Tarbutton for the people.
Good afternoon. You've been granted 5 minutes.
Thank you.
Counsel, Park Union versus 910 Union. Appellant's counsel sought no argument time. Counsel for respondent.
Good afternoon, Your Honor. Ethan Cobrey for the respondent.
Good afternoon. You've been granted 4 minutes, sir.
Thank you.
Martinez versus 560-568 Audubon. Counsel for appellant.
Manuel Gomez, Your Honor. Good afternoon.
Good afternoon, Mr. Gomez. You've been granted 4 minutes and respondent has sought no argument time. People versus Jermaine Hatchett. Counsel for appellant.
Yes, good afternoon, Your Honor. Barbara Zolat for appellant Jermaine Hatchett.
Good afternoon, Ms. Zolat. You've been granted 7-1. Counsel for respondent.
Hi, good afternoon, Your Honor. Jared Walkowitz for the people respondent.
Good afternoon, Mr. Walkowitz. You've been granted 7 minutes. People versus Hamza Sidibe. Counsel for appellant.
Good afternoon, Your Honor. Joseph Mercy representing Hamza Sidibe.
Good afternoon, Mr. Nursey. You've been granted 7-2, and I'll try to do better when we call the case on the pronunciation. Counsel for respondent.
Good afternoon, Your Honor. ADA Diana Lewis for the Bronx District Attorney's Office.
Good afternoon, Ms. Lewis. You've been granted 6 minutes. Hefferman versus New York City Mayor's Office. Counsel for appellant.
Good afternoon, Your Honor. This is Richard Welch on behalf of appellants.
Good afternoon, Mr. Welch. You've been granted 6-2. Counsel for respondent.
Good afternoon, Your Honor. This is Kate Fletcher for respondents.
Good afternoon. You've been granted 6-2 as you have a cross appeal.
Thank you.
Rabbit versus New York City Department of Housing Preservation is submitted, and Wu versus Spackman is submitted. First case on the calendar, People versus Anonymous. Mr. Palmer, you are up and you have 4 minutes.
My client is serving a 10-year sentence as a result of 2 incidents that occurrd at Rikers Island. This sentence is unduly harsh in light of the circumstances and the disparity between his sentence and his co-defendants. This court should run my client's sentences concurrently in the interest of justice. My client received a greater sentence than many of his co-defendants. On the 2017 indictment, my client's co-defendant's case was...
Counselor, wasn't your client facing 40 as a second felony offender in this case?
Yes, that was the possible maximum sentence if he got to trial and be convicted of the top counts.
And he received the minimum for each offense?
He received the minimum for each offense, yes. But I'm asking the court today to run these sentences concurrently in the interest of justice, as he received a greater sentence than all of his co-defendants in that.
Were
in the
all of his
27
co-defendants equally situated, counsel?
I'm not exactly sure about that.
Well,
But
that matters, right? In order for us to assess whether their sentences being lower is significant or not, or
Of course.
unfair, as you say.
But many of them some of those circumstances were similar in that all of these men, of course, were at Rikers Island for other matters. And contrary to the prosecution's suggestion in the respondent's brief, the file jacket here in this case shows that many of the co-defendants served or are serving concurrent sentences on other charges than they pleaded guilty to here.
Is your client being accused of being the principal actor in both instances?
No, that's unclear from the record. We do not have a complaint or other allegations in this case that would show who was the principal actor here, and we do not know my client's role in each of these offenses.
But Counselor, also was not another reason why your client did not receive the sentence that was perhaps promised was because your client violated the terms of and conditions of the plea, in that he violated the plea agreement?
Yes, he did violate the plea agreement. He did reoffend, but that said, that he only failed the cooperation agreement due to rearrest and thus received this enhanced sentence. 5 years, if these sentences were run concurrently, would still be longer than the 2 to 4 years he'd have served had he successfully
But that was
cooperated.
the whole point, Counsel. That was the whole point of the terms of the plea. The agreement was that he was going to engage in certain conduct, and if he engaged in that conduct, he would receive the promised plea. He failed to live up to the terms and conditions of the agreement, and therefore he was sentenced as he had been told he would be sentenced upon his failure to live up to the terms of the agreement.
Correct. He did agree prior to being released that he would not reoffend as a part of the cooperation agreement. And he did receive the consecutive sentence as promised. But here,
Mr. Palmer, now, am I correct that at the time of conviction, the defendant had 3 prior felony convictions and 6 prior misdemeanor convictions?
yes, that is accurate, Your Honor. But his status as a predicate felony offender sufficiently accounted for his record. As a first felony offender with these same charges or as conviction, could have received a sentence as low as an unconditional discharge or a 1.5 to 3 year sentence. And also compared to his co-defendants, they also seem to have prior.
You make reference to his co-defendants, but when the question was asked as to whether or not he was in the same position as his co-defendants, you accurately stated that you did not know whether that was true or not. But I just want to be clear. Why should we in any way reduce your client's sentence where it was clear that he violated, again, the terms and conditions of the agreement, which he was made fully aware of? What is there in the record which would allow us to say, okay, although you breached the terms of the agreement, we are still going to reduce your sentence?
Well, Your Honor, part of this court's role in being able to reduce sentences that are unduly harsh or excessive, is to account for sentencing disparities. And yes, he did violate the conditions of his plea agreement, but he does appear to be the only, if not one of the only, defendants here who is serving a consecutive sentence as a result of these charges.
Did the other defendants, did his co-defendants breach a cooperation agreement as well?
I do not know that, Your Honor.
And were all of the co-defendants involved in both altercations? I understand the first incident from 2016 involved just your client, and the second incident in October of 2016 involved 6 co-defendants. So did the 6 were the 6 co-defendants charged in another case like your client was?
He is the only defendant here whose cases overlap these two indictments, but of course, as a matter of
So in
being
other
in
words,
at
the counsel, so in other words, the co-defendants were not open to being subjected to consecutive sentences.
well,
So that wasn't even on the table for them.
well, these co-defendants
right?
did have these co-defendants did have other cases and could have been sentenced consecutively in those cases. But as the file jacket in this case, as a part of the record and appeal,
Yes, but
makes
counsel,
clear.
everybody in Rikers Island has a case. That's not what I'm talking about. Your client had a case, and he then had 2 incidents of violence within Rikers Island. Am I incorrect about that?
No, you're not incorrect, Your Honor.
Okay, so everyone in Rikers, we all get, has a case, right? But the 2 cases your client is being sentenced for are for violence during his stay at Rikers.
Correct. And when he
the
pleaded guilty,
other co-defendants only had 1 of those cases as far as this record is concerned.
yes, but
You'll have time on rebuttal.
Thank you.
Okay, you have 2 minutes on rebuttal. Counsel for respondent, I'll hear you, 4 minutes.
Thank you. May it please the court, Daniel Young for the Office of the Bronx District Attorney. Your Honors, defendant's sentence of 2 consecutive 5-year terms of imprisonment were fair and proper. Here, unlike his co-defendants, defendant was charged in 2 separate indictments, one for attacking another inmate and one for attacking a corrections officer with the assistance of 6 other men who were being held on Rikers Island.
Now, counsel, am I right that the September 15, 2016 Rikers Island incident only involved a punch in the face?
I believe that is correct, Your Honor, yes.
And this man is doing 5 years for a punch in the face?
Based upon the record, that does appear to be correct. However,
and you don't think that's excessive?
Your Honor, he has 3 prior violent felonies. And
I get that. I understand that. Okay. But we can't say 5 years is an appropriate sentence for a punch in the face and 5 years is appropriate for creating a weapon while inside Rikers. I don't think those 2 things are equal. Do you?
Your Honor, I believe the punch in the face incident was done with the assistance of others, while he was being housed on Rikers Island against a corrections
That wasn't my
officer.
question. Do you think a punch in the face and creating a dangerous instrument are the same thing and should warrant the same punishment?
They are not the same thing, but they do warrant the same punishment given the circumstances under which each occurred. Again, this was an attack done in Rikers Island with the assistance of others.
Except that no one else was charged.
In the original indictment, there was an additionally charged person. However, those charges were dropped eventually.
So then
and we do not
only one person that you pursued in terms of prosecution whose involvement you thought was sufficient enough to proceed.
That is correct, Your Honor.
Okay, so, all right. You're maintaining your position that a punch in the face and the possession and creation of a sharp instrument in prison should warrant the same 5-year sentence consecutively.
Given the circumstances of both of these happening while he was already being housed in Rikers Island, yes, that is correct.
Counselor, this is Judge Singh. Was this a negotiated sentence?
Yes, Your Honor. This was a negotiation.
Was there a waiver? Was there a waiver signed in this case?
Yes, Your Honor. This was
a waiver. Is the waiver valid?
Yes, Your Honor. This was a negotiated sentence. Originally, the offer was to plead to the drug charges or the contraband charges, sorry, and receive 2 to 4 years incarceration. However, defendant did not. Defendant violated his cooperation agreement and was instead sentenced to the 2 5-year concurrent sentences.
Did he ever testify?
Your Honor, the record is unclear as to whether or not he testified or how he violated the cooperation agreement, aside from being arrested after entering into
Well, that's what I'm
cooperation.
asking you. Is the only basis for the violation of the cooperation agreement his rearrest, or did he also fail to testify pursuant to that cooperation agreement?
The record is unclear as to whether he failed to testify. However, regardless, he still violated the cooperation agreement, and he received the sentence that he knew that he would receive if he violated the
Well, I mean, the
cooperation.
reason I ask is because if he testified and the reason he has a second arrest was because he was defending himself inside, because now he has a target on his back for having cooperated with the prosecution, that again would be a factor this court should consider in whether consecutive sentences is appropriate.
And I agree with that, Your Honor. However, there's no indication in the record that that's what occurred. Defense counsel and defendant both had an opportunity to speak at defendant's sentencing, and neither of them placed that information on the record.
Okay.
As to Judge Singh's prior question, there was a waiver of the right to appeal here. The court advised defendant that it was separate from the trial rights that defendant was automatically waiving as part of his plea. The court specifically said that this was because of the agreement with the people, not the plea itself. Furthermore, there was a written waiver of appeal that defendant was unable to assign on his own because he was in mittens placed on him by the Department of Corrections. However, this was signed and executed by his attorney, who he had authorized to sign and execute the cooperation agreement previously. So there's no reason to believe that the attorney did not go over this with him prior to signing it on behalf of defendant. The written.
We're out of time, but we
Thank
have your briefs and we have your arguments. Thank you.
Thank you, Judge.
Counsel, you have 2 minutes, Mr. Palmer.
Thank you. As you were saying during the response argument, Judge Manzanet, that yes, one of these events was simply him punching another person in the face. That's what the record shows. And he pleaded guilty to intentionally causing physical injury while incarcerated at Rikers Island. Based on his plea, if this had took place, at Liberty, it could have simply been misdemeanor assault. And as far as the contraband charge, those charges were dropped as a part of the plea when he was sentenced. And additionally, my client did not validly waive his right to appeal. The court here, during the colloquy, suggested that the appeal was an absolute bar to taking an appeal, and that he said that our client had to agree that this is the final stage and there will be no appeal, and asked him if he was ready as a part of the agreement to forgo an appeal. The court did not explain.
Counsel, I'm sorry, where in the record does it state that? Because I read the waiver. I did not see that the court at any point said this was a complete bar.
On the bottom of page 15 into page 16 of the plea minutes, the court says, in other words, if the people said this is your agreement, you have to agree that this is the final stage and there will be no appeal. So your right to appeal will be waived pursuant to cooperation and plea agreement. Are you now prepared, as a part of this agreement, to forgo an appeal, to waive your right to appeal, and fulfill that part of this agreement? And the court did not explain or clarify what, if any, issues or rights would survive that waiver. And it's not a case, of course, where the written waiver would save this misguided oral colloquy, because the court did not ensure that our client had actually read the agreement.
The court went on to say you have a right to appeal under normal circumstances. You have a right. It says that.
Right, but in describing what the waiver was, the court said that he would be foregoing appeal. There would be no appeal. It is the final stage. And yes, there was a written waiver, but the court did not ask my client whether he actually read the form, discussed it with counsel, or understood it. So his conditions, his understanding of the terms, conditions of the waiver are not apparent on the face of the record as they should be. And as his 10-year sentence was excessive, he had not waived his right to appeal. This court should run my client's sentences concurrently in the interest of justice. Thank you.
Thank you. People v. Elisette Jesus. Ms. Gladstein, you have 4 minutes.
Good afternoon. This is Hannah Gladstein for the appellant, Ms. Jesus. Ms. Jesus was convicted of a small amount of heroin to a friend of hers who she happened to run into while on her way to buy for herself. She is a person who had been struggling with mental health and substance use for much of her life, and she has an entirely nonviolent criminal history that is directly linked to these risk factors. She poses no risk to community safety.
Counselor, this is Judge Singh. Counselor, tell me, just give me some sense in terms of what's happened to your client since she's been on probation. Has she gotten in trouble? What's occurred?
She has been doing great, Your Honor. She has had no new arrests. She has continued to participate with her program, both the psychiatric piece and the substance abuse piece.
Let me stop you for a second. So that's through probation, correct?
Actually, she's just been doing the same program that she's been doing all along. That's something I want to underscore for the court, is that really, while probation has, provided some encouragement along the way, her achievements really are her own. This is the program that she went into probation doing. She's continued doing it. She's achieved a reduction in her methadone dose. She got an apartment for herself on her own. That just happened in the last couple months. She finally has her own place. And she's done all of this in the face of a pandemic, and also in the last year losing her father and her son, tremendous personal hardship, and has not incurred any new arrests or any relapses. She's just been doing really quite well.
How much time does she have left on her probation?
About another 6 months, Your Honor.
And Counselor, how often does she actually report to probation? Because since she's at the end of the probationary sentence, it was my understanding that these probationers would only report maybe once a month or by phone, especially during the pandemic. So how often is she actually reporting to probation?
That's a good question. And I believe it is at this point, she is down to once a month. I do want to underscore that on top of her other obligations and with, the disruption and the chaos in the world, any additional obligation is an additional burden that is being placed on her.
And that once a month, that's telephonic, is it not? I mean, she's calling in, she's not doing it in person, right?
I honestly don't know. And I do think that in-person reporting is starting to happen again, but I can't say for sure. She just, when she moved a couple months ago, she had to transfer her probation from the Bronx to Manhattan. And sometime, I don't know what the situation is with her new PO. I just don't have that information.
Ms. Gladstein, I just want to make sure that I understand. It's your contention that probation has not provided any services and that defendant on her own sought out various services?
Well, Your Honor, probation, I don't want to say that probation is of no help. What I meant was that she was already engaged with services at the time that she went on probation. She was receiving mental health and substance use, and probation continued her in the programs she was already in. And she has continued to participate with those programs. Probation has checked in with her, obviously, to make sure that she's compliant with those programs. And I am aware that probation also provided her at some point with some budgeting assistance, which did, I'm sure, help her achieve the point where she was able to go out and get her own apartment. What I just meant to convey to Your Honors is that, she is a person who's really capable of doing these things for herself. And she has achieved quite a bit for herself in the face of pretty significant obstacles.
Thank you so much. We appreciate your argument and her progress. Thank you so much.
Thank you.
Deca Immobiline versus Lexington Avenue Hotel. Mr. Bergman, you have 5 minutes.
Thank you, Your Honor. Good afternoon, and may it please the court. Jed Bergman, Glenager, Bergman, and Fuentes on behalf of Plaintiff Appellant Deca Immobilian. Your Honors, this was a proper case for CPLR 3213 relief, and the Supreme Court erred in denying summary judgment. The main thing I want to do this afternoon is address any questions the court may have, but there are 5 particular things I'd like to emphasize. The first, the only real issue in dispute in this matter is standing, and Deca has 2 independent grounds for standing: subrogation and assignment. If we win on either one, the decision below must be reversed. Second,
Well, Counselor, looking at the assignment agreement, which is governed by New York law, was the plaintiff the guarantor in this case?
absolutely, Justice Singh. The plaintiff,
And how do you establish that in the assignment agreement?
It's not established in the assignment agreement. It's already an existing fact under German law, which I'd be happy to address, Justice Singh. That's actually where I wanted to start, because it covers subrogation also, is the undisputed record establishing that Decca Immobilien is the guarantor. Section 778 of the German Civil Code says that a person who instructs another to make a loan becomes a guarantor, and that's reproduced at page 103 in the record. The credit mandate is the document by which Decca, quote, hereby instructs, close quote, Bayern, the original lender, to make the loan. That's at page 79. And the loan agreement that followed, which is at page 56, among others in the record, recites on page 1 that Decca, which is defined there as the KVG, instructed Bayern to make the loan. So Decca is the party that instructed the loan, and under section 778, Decca is the guarantor, plain and simple.
And signed on that loan agreement, correct?
And signed on the loan agreement as well as signed on the guarantee.
I guess what I'm trying to get at is looking at the assignment agreement, because there are different spins the parties have with respect to what German law is. But looking at the assignment agreement, is the assignment agreement sufficient basis to confer standing on your client?
So the answer to that question, Justice Singh, is yes. The assignment agreement is a sufficient basis to confer standing. There's actually no dispute between the parties as to the validity of the assignment agreement on its own. The only dispute as to assignment has to do with whether section 11.5 of the loan agreement operates to restrict the assignment. It does not, because there was an event of default here. And there's a lot about this in the briefs, but it really coalesces.
And the response by the defendants is that if you look at the documents, the failure to pay the loan, arguably, when it came due, is not an event of default. How do you respond to that?
That's incorrect, and the loan agreement is unambiguously to the contrary. So section 11.5, which is the restraint on assignment, uses the term event of default, lowercase undefined. In their reply brief, the borrower actually agrees that the undefined term default includes a maturity default, which is what happened here. The only argument to the contrary, the only argument that the borrower offers is that section 9 of the loan agreement somehow restricts or defines the term event of default to exclude that maturity default. But if you look at section 9, which is at page 64 in the record, it's very clear it does nothing of the sort. It's not a definition. It doesn't say it's a definition. It doesn't purport to address section 11.5, and it's emphatically non-exclusive. The opening words of section 9 say, notwithstanding any rights of early termination given by law or other governing documents. And the only events of default that are listed there don't relate to the borrower at all. They relate to Decca, to the fund, or to the property. So there's simply no way to read section 9 as an exclusive enumeration of events of default. And what that means is the plain meaning in 11.5 governs, under which the borrower agrees there was an event of default here and there's no restraint on assignment.
Well, what about with respect to the general terms and conditions? Those have been incorporated into the loan agreement, correct?
Correct.
And do they provide a basis for finding a default?
They don't, because they don't need to. Those are also additional events of default. And really, once we get away from section 9, what we have in the borrower's reply brief is the concession that the plain meaning of default and the plain meaning of event of default includes a maturity default. So if section 9 doesn't change that definition, there's no restraint on assignment, and the assignment also applies.
And indeed, one of the primary arguments against you or against your client is that they interfered in the ability to obtain an extension so that they would not default.
It's an argument. I think the case law we set out in our brief establishes that such defenses having to do with breach of fiduciary duty, which duty doesn't exist, by the way, for us as a limited partner, are separate and severable from the 30.
That was a friendly statement, by the way.
I'm sorry. I'm sorry. I appreciate it, Justice Mentonet.
That's okay. You'll have time on rebuttal.
Thank you.
Counsel for respondent, Mr. Wurtzel.
Good afternoon, Josh Wurtzel for the respondent. May it please the court. Mr. Bergman stated that we conceded that a default
we lost
includes non-payment. I'm sorry, can you hear me?
We lost you for a moment, so if you could repeat your point.
I apologize. Mr. Bergman said that we conceded in our reply brief that an event of default or a default includes non-payment of maturity. I don't disagree that that is the common meaning of default under the common ordinary dictionary usage, okay? But we have a loan agreement. We have section 9 of a loan agreement that's titled events of default. And then it goes out and lists about 8 or 9 different things. Mr. Bergman says, well, it's not a definition. But what is conspicuously missing from section 9 here is anything saying, here are a bunch of events of default, but this is not limited to just these events, or including but not limited.
Section 9 references the general terms and conditions, and that section provides for termination and that the loan is immediately due and payable where the borrower is in default.
That's correct, Your Honor. But the general terms and conditions also do not include in their definition of events of default. And by the way, I don't think they actually have
which means that under the law, we typically go to the common understanding of that term, no? And certainly failing to make your payments is one of them. Without question, that is about as black letter law as you can get.
That's correct, Your Honor. But what we have here, and what it says about the general terms and conditions in section 9, it's titled events of default. And then it says, notwithstanding any rights of early termination given by law, according to the general terms and conditions for loans and the general business conditions, the bank is entitled to terminate the loan for good cause. And then it lists a number of events of default. It never says, well, here are some events of default, but then there are other events of default listed in the general terms and conditions. By the way,
Counselor, as my colleague just mentioned, what would be the more basic default than failure to pay a loan on maturity? I understand your argument. It's a nuanced argument, but can you respond to her question?
I think under the common understanding of the word event of default or default, non-payment upon maturity is probably the most basic or most quintessential definition of default. But we've cited case law, and I think everyone on this call understands that when you have a defined term, when you have a specific usage of a term in a contract, it doesn't matter that specific usage of a term, that specific term might have a different meaning under ordinary dictionary definitions.
If it's not defined, we go with what is the common understanding of the term. That's black letter law. So you can, articulate it whichever way you want. You're not going to be able to get around that one, counsel. Do you have any other arguments?
So, Your Honor, I do. So the other part of this is that it has to be that there was an event of default that was and is continuing. The record here, and it's not disputed, is that
because I know where you're going, the payment by the plaintiff here does not excuse your client's default.
Well, Your Honor,
it does not.
The argument that they're making is that they step into the bank's shoes, but the bank has been fully satisfied, so they might have a claim for subrogation.
At the time as they satisfied the loan, they also signed and received an assignment of the bank's rights. And therefore, they are not out of luck.
Your Honor,
your client still owes that debt.
Your Honor, respectfully, I disagree. It was not, and actually it was not at the exact same time. It wasn't simultaneous. The assignment agreement says that it was.
They were on the same
done-
day, right, counsel?
It might have been on the same
Dated
day.
the same day, right, counsel?
I believe that's correct.
Okay.
But Your Honor, the issue here, and there's I think a federal case from within the Third Circuit that deals with this exact issue that we cited in our reply, which is that when there is a payment by a guarantor, the guarantor then steps into the shoes of the original lender. But that does not mean that there is still an existing default at that time. The remedy in that instance for DECA was to sue for subrogation, which they've done, but for it wasn't done properly here. But we're not saying that they don't get to recover if there's proper subrogation. What we're saying here is that they needed the borrower's consent to receive an assignment.
You were in default, and under the agreement, your consent was not needed if you were in default, and you were in default.
Your Honor, respectfully, I disagree.
We know what respect
means,
counsel.
Counselor, just going back to that point, is plaintiff a third party in this case?
Yes, it is, Your Honor.
But wait, but let's just go through that. Let's go through that. Plaintiff signed the loan agreement, correct? And is a party to the agreement, correct? And isn't plaintiff referenced throughout the loan agreement? Under those circumstances, how is it a third party to the agreement?
So, Your Honor, there's actually, I'm just looking for it now, there's actually a definition of third party in the agreement. And give me a second to just pull it up. There is a definition of a third party in section 11.2 of the agreement. It's on page 65 of the record. And there's a definition here, and it says that a third party is a member of the European system of central banks, the European Investment Bank, a credit of a financial institution, a finance institution, or an investment trust. There's no dispute here that DECA LP is an investment trust. It doesn't say in section.
But can't DECA be wearing two hats in those circumstances? If it signed the loan agreement, it seems to me that it's a party to the agreement. No.
Well, it's a party to the agreement, but it's not an obligor and it's not a lender. And specifically, Your Honor, I think at the very least, and we've cross-moved here, but at the very least, there has to be an issue of fact about whether, in fact, DECA was considered a third party under the agreement, whether when the parties negotiated section 11.2, whether it was intentionally omitted that DECA was not carved out of the investment trust definition, or if in fact DECA was deemed to be a third party.
Okay, thank you so much. We're out of time. I've given you 4 extra minutes. Mr. Bergman, I'll give you 2 minutes.
Thank you, Your Honor. Just briefly, to the point that Justice Singh was raising, DECA is not a third party within the meaning of this provision. It signed the loan agreement. It has obligations under it. It's referenced throughout. It's not a third party. But even if it was, there clearly was an event of default under the plain meaning of the term. Section 9, by the way, on which the borrower relies so heavily, is not a definition, and the easiest way to see that is by looking at 11.2, which counsel just referenced. That's what a definition looks like. Third party within the meaning of this clause is. Section 9 is not a definition. The events it lists are all pre-termination, even if it was. It's got nothing to do with the failure to repay the loan at maturity. The case from the Third Circuit on which the borrower mentioned earlier, which is a case from the District of the Virgin Islands, is completely unlike this case. That's Day versus White. In that case, the two parties were not, as they are here, a borrower and a guarantor. The parties were co-obligors. So when one paid the shared obligation, the loan was discharged. That was it. And just one point briefly, I didn't get to my 5 before. I'm not planning to get to them now, but I do think this one is important to call to the attention of the court because it goes to the borrower's credibility. The borrower argues in its briefs that Bayern signed the loan agreement before it accepted the credit mandate. And to support that, it claims that there's a transmittal email from DECA sending the credit mandate to the bank, to Bayern, which included a loan agreement that Bayern had already signed. Your Honors, that is demonstrably false. The signed agreement that the borrower cites to, which is at page 480 of the record, isn't part of the transmittal email at all. It's part of a completely separate exhibit that ends at page 469. So to be clear, the borrower is representing to the court that a transmittal email included a countersigned loan agreement, even though it does not. So the argument fails. The borrower's lack of candor respectfully speaks volumes, and we respectfully request that the case be reversed, remanded for the entry of summary judgment and the calculation of interest and fees. Thank you.
Thank you so much. People versus Travell, London. Mr. Greenberg, you have 5 minutes.
Thank you, Your Honor. Simon Greenberg for Appellant Travell, London. The prosecution correctly conceded that the sentence and the predicate violent felony adjudication based on the Colorado second-degree burglary conviction must both be vacated. We argue the court should also vacate the guilty plea because there is a reasonable possibility that the trial court's erroneous ruling had contributed to Mr. London's decision to plead guilty. And that is clearly.
And how do you reach that conclusion, sir?
We reached that conclusion because immediately after the judge made this erroneous ruling, my client pleaded guilty. There was an offer on the table before the ruling was made, and then immediately afterward, basically the same day, my client decided to accept the court's offer, and so that time, the time frame in which there was a relationship between the timing of the decision and the decision to plead the predicate felony decision and the decision to plead guilty shows a causal, or at least a reasonable possibility of a causal relationship between the judges.
Counsel, on almost every case where determinations like this and determinations on suppression motions are made, it is followed by a plea. So if we were to take your argument forward, it would be the basis to withdraw almost every single plea that we take in this state.
Well, in cases in which there is an erroneous.
This happens every day in courtrooms throughout the state. Is my point.
And
so there's got to be more than just that.
Well, I think that the burden is really on it is common for an incorrect suppression ruling immediately followed by a guilty plea.
I didn't say that, counsel. What I'm saying is it is common that after a suppression decision, denying the suppression hearing, right or wrong, I can't assess that until the case is before me, obviously. But what I am saying to you, and I am sure you will agree as a seasoned defense attorney, that it is not uncommon at all for a defendant to take a plea when they have rolled the dice on various hearings and they lose. Because now it's, sink or swim. You either take a plea or you go to trial.
Yes, Your Honor, we do agree with that. But it is also common that if the appellate division decides that the ruling was erroneously made against the defendant, that the defendant gets their plea back once the appellate division rules in their favor on the ruling that preceded the plea, whether it be a suppression ruling or, as in this case, a predicate felony adjudication.
No, it would be that we would remand for further proceedings consistent with our determination. And in this particular instance, that is what the request is, that we remand for further proceedings based upon the fact that the ruling as to the predicate felony was inaccurate, was incorrect. But I don't see how we would then allow the defendant, I mean, again, as Justice Mazzanett-Daniels stated, there's nothing here which would lead us, that I see in the record, which would lead us to conclude that the defendant's plea was not knowing and voluntary, but rather based upon the fact that he was now adjudicated a predicate felon. And there are numerous cases where individuals have been adjudicated a predicate felon, where it's been later determined that they were not, in fact, a predicate felon because there was some type of issue with the predicate felony statement, and therefore the sentencing would be vacated, but not that the plea would be vacated as not being knowing and voluntary.
That's correct, Your Honor. There are cases in which the reversal of the predicate felony ruling does not lead to also a vacature of the plea. But here, the ruling was made right before the plea decision was made, and that makes this case.
When would you have liked the ruling to have been made? Well, I'm just curious. When should the defendant have been apprised of the fact that the people were seeking to have him sentenced if in fact he pled guilty as a predicate felon? When do you think the defendant should have been apprised of that information? And do you not believe that that would have been information that obviously the defendant should have considered? And you probably would have been arguing that if the circumstances were different. Oh, the defendant was not aware of the fact that the people were going to be seeking to file a predicate felony statement?
I don't disagree. I think it was perfectly proper, Your Honor, for the ruling on the predicate felony to be made before the plea. But we're not making a voluntariness issue. We're making.
So again, where in the record can you point us to suggest that the defendant only pled guilty, again, not because he was in fact guilty, but rather he pled guilty because somehow he was persuaded or intimidated by the fact that the people were filing a predicate felony statement?
Well, as we said in our brief, Your Honor, and as we've already said, I've already said in this oral argument, the key fact that we are relying on is that the predicate felony ruling was made right before the decision to plead guilty, and so he had not decided to plead guilty yet before the predicate felony ruling was made.
Okay, you'll have 2 minutes on rebuttal. We're already 2 minutes over time. All right?
Yes, Your Honor.
Mr. Tarpon?
Yes, Your Honor.
I'm sure I mangled your name, and my apologies to you.
Actually, that was right, Tarbutton. No,
Oh,
no one
good.
believes it.
Okay, good.
Your Honors, this discussion of the voluntariness of the defendant's plea and of harmless error analysis is premature. It's not even clear at this point that there was an error. The defendant's argument that he's entitled to vacature of the plea is entirely dependent on the assumption that when he pled guilty, he mistakenly believed that he was a predicate felony offender. But at this point, we don't know that that was a mistake. The defendant might very well be an actual fact a predicate felony offender, and we can't determine that issue until this case is remanded to the sentencing court for further predicate proceedings.
Yeah, that is correct. However, I'm taken by the people's argument. This issue as to the Colorado conviction has already been adjudicated and decided that the Colorado conviction cannot be used as a predicate in this case because the elements of the crime that he pled guilty in Colorado, I thought it was a burglary or whatever, does not rise to the level of a violent felony here in New York. So what I thought was interesting with your argument is that you believe that somehow you should get 2 bites at the apple, that you should now be able to relitigate that issue and to argue that the Colorado statute does comport with a felony here in New York?
Yes, Your Honor, because that's what this court held in People v. Ambroise and People v. Vines. In both those cases, the court permitted the people to relitigate the predicate status of the defendant based on the same prior conviction that it held the initial predicate adjudication was erroneous. We're entitled to a second bite at the apple on the same one. That is our position, I think.
Counselor, this is Judge Singh. Isn't there another conviction that you're arguing that may form the basis, and that's the felony escape in Colorado in 2008?
Yes, Your Honor, there is. There are also 2 other felony robbery prosecutions.
So why should you, under the circumstances, get a second bite at the apple when maybe you have 2 other bases to reach that same determination?
Well, we very well might not even address the burglary if we have it on another conviction, Your Honor, but we're entitled to explore all these issues on remand. In fact, in People versus Juergens, the Court of Appeals made clear that we don't have to make a showing at this point that any of these prior convictions would constitute predicates, and in fact, we usually can't because we wouldn't have a full record yet without the record being developed. In Juergens, the court said that people are entitled to remand and further predicate proceedings where they can establish the predicate status based on defendant's other prior conviction if there is one. So we don't have to establish that there's a qualifying one. And again, in this court in Ambroise and in Vines recognize that we can use the same one. So we're not limited on any of these issues. These are all issues that ought to be fleshed out if necessary on remand. One thing I'd like to address, Your Honors, is the defendant's argument in the reply brief that this court ought to sort of preemptively issue an instruction to the hearing court that it ought not reconsider the Colorado burglary conviction, the one that was used here, on the ground that People versus Ola prohibits the people from introducing further materials. And because this case doesn't fall into the exception that Juergens of the cases recognize, the exception to Ola, where you can resort to the accusatory instrument and the plea minutes and other things to establish that conviction would constitute a predicate here. The first problem with that is there's a Lafontaine problem. The court actually doesn't have jurisdiction to issue such a ruling because the court below never reached it itself. There's no ruling. The parties litigated that issue, but the court held that the Colorado burglary statute and the New York burglary statute had identical elements. So it didn't have to reach the issue of whether there were different versions, different species of burglary, whether it was appropriate under OLA for the court to resort to the examining the accusatory instrument to determine which species of burglary, which elements were the relevant ones. So since the court never reached that, there's no ruling to review. So the court certainly shouldn't remand with these limiting instructions. There's also, Your Honor, as you pointed out, we might not even reach the burglary. I'm sure if that felony escape qualifies, if these robbery prosecutions turn out to have led to convictions that qualify, we probably won't be reaching the burglary. So it's inefficient for the court to reach out and reach an issue here when it might not even be relevant on remand.
Thank you so much.
Thank you, Your Honor.
Mr. Greenberg, you have 2 minutes.
Thank you, Your Honor. There is no Lafontaine bar here to the court ruling that there should not be an opportunity to supplement the record as to the Colorado burglary conviction, because the issue on appeal is whether the Colorado conviction is a predicate violent felony. It doesn't get chopped up into sub issues so that the court has to wait until the trial court rules on the question of whether the OLA exception applies before this court can reach that issue. So this court certainly has jurisdiction to instruct the trial court that the litigation as to this Colorado burglary is over and the OLA exception does not apply. And also the fact that the people might not even try to supplement the record as to the burglary conviction is not a good reason for this court to not say what the law is. There's no reason to, the people say in their respondent's brief that they might seek the plea minutes from that Colorado case in order to try to prove that the Colorado conviction actually was equivalent to a New York felony. So if the people are saying in their respondent's brief that they would like an opportunity to do that, I don't think it makes sense to say, well, we shouldn't say anything because they also might not do it. I mean, they've said in their brief that they would like to do it. So I think that this court should address the issue so that the trial court has guidance about what should happen at a resentencing if that's the remedy that the court orders.
Thank you.
Thank you, Your Honor.
Park Union Condominium versus 910 Union Street. Appellant did not request argument time. Ethan Cobry, you have 4 minutes.
Good afternoon, Your Honors, and may it please the court. This was a breach of contract action that was brought on by summary judgment in lieu of complaint. So the CPLR default interest rules apply. Interest is mandatory, and that's in keeping with black letter law in New York, including the CRP Extel case. Justice Manzanet, I believe you were on the panel in that one. Interest is mandatory. This is no different than any other breach of contract case. This is not a case where there was a sole or exclusive remedy provision in the party's contract. Frankly, I think it's dishonest to even suggest otherwise. And Justice Scarpula was correct to award my client's statutory interest. Justice Scarpula was also correct in dismissing the third-party complaint and denying leave to amend it for a host of reasons. Number one, the general obligations law bars claims against my clients, the third-party defendants, and this is an issue that for some reason appellants chose not even to raise in their appellate briefs. None of my clients owed any fiduciary duties to the sponsor. My clients' decisions as a board are protected by New York's business judgment rule. There are no allegations of independent tortious conduct by any of my clients. So it was certainly correct for Justice Scarpula to dismiss the third-party complaint, and it was equally correct for her to deny leave to amend that third-party complaint. Appellants only sought to repackage their claims. They didn't add anything new. And, you know, to me, most glaringly, any sort of proposed amended complaint was barred by this court's prior decision in this very action, where the court held that all of the gripes that the appellants were trying to now raise were, quote, unavailing as a matter of law. So we respectfully submit that the lower court's decision should be affirmed. And if your honors have any questions, I'm happy to answer them.
Doesn't look like it. Thank you so much.
Thank you. Have a good afternoon.
You too. Inez Martinez versus 568 Audubon Realty. Mr. Gomez, you have 4 minutes. Unmute your mic, sir.
Good afternoon, and thank you, Your Honor, and may it please the court. I'm the attorney for Ms. Martinez. Ms. Martinez, going down the staircase of an apartment building, fell down when her ankle got caught on the edge of a crack.
Mr. Gomez, just a quick question. What was the cause of her fall in this case?
The edge of a marble step was cracked. As she was going down the stairs, her foot got caught on the crack of the step, falling forward.
But is that what you reported to her family, to the urgent care center? What did you report to them? What caused her fall, if anything?
That she fell down. Yeah, and there was during her deposition, there was also water. There was also she mentioned water also at some point.
Yeah, I think she said she fell on slippery stairs, right?
On slippery stairs, that's right. But at the very time, on the very day of her accident, she took pictures of the step. Those pictures are in 342 and on 343 of the record. And that step showed that there was a crack on the edge of the step of the marble step. Yes, she did mention water, but she on the slippery water. But later, with the photos and at her deposition, she mentioned that her foot was caught on the cracked marble step and she fell forward.
Well, to urgent care, let's be clear. She said it was a slippery stair, and also she never reported the incident to the building staff. Is that correct?
That's correct. Yeah, she never reported the fall. Right. Yeah.
And so how do you establish notice in this case, sir?
Okay. Well, first of all, we argue that they never met their burden in the first place. But notice was established because we submitted the affidavit of a witness, Eva Gomez, who lives on the 5th floor of the building. Eva Gomez testified that the crack in the step was around for at least 90 days before the accident. The lower court did not permit Ms. Gomez's affidavit because they felt that we waited until the last minute to submit her affidavit. But I argued then, and I argue now, that Ms. Gomez was a known, or should have been, a known witness, a known notice witness to the defendant if they had conducted a due diligence investigation.
Well, but let's circle back to the PC order. Weren't you required to provide notice witnesses, disclose notice witnesses.
Right, at that
And
time,
so isn't that arguably a violation of the PC order by not providing it until there's a motion for summary judgment, which you would agree does put the other side at a disadvantage because it can't take a deposition, et cetera, et cetera. No?
all right. Well, if I'm not aware of her, as I say in my affidavit in the lower court, I did not know that this witness existed at the time of the PC.
Well, it seems to me that's what investigations are for. No, you send an investigator out to speak to other tenants in the building, et cetera, all the stuff you normally do when you bear a case for trial.
Right.
And also, go ahead. I'm sorry. Go ahead.
I was just going to say, yes, but that same argument would apply to the defendant if they were to raise surprise witness, unknown, because they also, this is in their building. This is in their building where the accident took place. So they also would conduct their own investigation and would not be able to argue that this was an unknown last-minute witness.
But again, to your affidavit, you stated in your affidavit that you were not aware of Ms. Gomez, but you did not state when you became aware of Ms. Gomez, how you became aware of Ms. Gomez, and again, why this information was not provided earlier. So I believe the motion court also found that the affidavit was also insufficient.
It's insufficient, if at all, with respect to my giving a fuller explanation. I gave like a boilerplate explanation that it's really never really known when witnesses will be discovered. I do say that it's never known when a particular witness will be discovered, implying that at the time of the PC order, I was unaware of that. After the motion, everybody's attention becomes focused and investigation goes out. Okay, but
Mr. Gomez, how do you reconcile your argument with our case law, where we have repeatedly affirmed motion courts that decline to consider the affidavit of a witness that had been, belatedly produced, particularly submitted in opposition to a motion? So how do you reconcile your argument with our case law?
Okay, the cases that the lower court cited were Garcia and Ravanoff, and in both those cases, the witness was a family member of the plaintiff, only known to the plaintiff. In this case, it's very different. The witness, Ms. Gomez, could have just as easily been known to the defendant, no differently than to me by doing a due diligence investigation. So this
Mr. Gomez, we've also affirmed when the witness wasn't a family member.
Yes, but the issue is not whether they're a family member. I sort of misspoke. The issue is whether this witness could have been known to the defendant, could have been known. And in both Garcia and in Ravanoff, the witness could not have been known to the defendant absent the plaintiff making the revelation. Okay. In this particular case, in the case of Ms. Martinez.
Thank you. We are way over time, but we've got your arguments and your record. Thank you so much, Mr. Gomez. Okay, People versus Jermaine Hatchett. Ms. Zolat.
Thank you, Your Honor. May it please the court, Barbara Zolat for Appellant Jermaine Hatchett. Your Honors, the police violated my client's Fourth Amendment rights when they searched his jeans while he lay injured on the ground of Washington Square Park. To begin, the Fourth Amendment applied to this search and protected my client's expectation of privacy.
Counselor, this is Judge Singh. Does a call for help imply or is sufficient for implied consent?
No, Your Honor, that's getting right to the issue here. What the hearing court found was that because the pants themselves could have been seized as evidence of a crime, even though my client was at that point believed to be the victim, that the police were then justified under the doctrine of implied consent to go into my client's jeans pockets because he had summoned for their assistance, he had needed assistance. However, the fact that the pants were seized did require independent justification, as the hearing court found, but the hearing court was wrong in finding that my client impliedly consented and that provided the independent basis for the search. There is no authority. In fact, that argument was not even made by the prosecution below. to the hearing court. Neither the people on appeal now nor the court below provided any authority for the idea that when someone is seeking the help of the police, they are thereby impliedly consenting to the police searching through their belongings. In fact, that would be a very radical extension of the doctrine of consent and would subvert the heavy burden that is placed on the prosecution of proving consent. It would really have very broad implications because it would mean that anytime someone is injured and summons the police for help, they're thereby impliedly consenting to the police going through their belongings.
Here the facts were a little more nuanced than that, in that your client was going in and out of consciousness, right? And could not articulate his own name. So are you saying that if police are summoned to help and the person is unresponsive, that the police are not permitted to check that person's wallet for their name, or their pants pocket for a wallet, or their purse for identifying information? Is that your argument?
That is not my argument. The police can do that. The issue is whether the fruits of that search, that investigation for identification, are then admissible at a criminal trial under the Fourth Amendment. The police can look for identification, but the question is, what can then be done with those fruits? And our argument is that unless there is a justification, a lawful basis for that search under the Fourth Amendment, then the fruits of that search are not subsequently admissible at a criminal
So let's assume drugs were found in the pocket. So your position would be the same in this case?
Yes, it would be, Your Honor.
And if a gun was found, so they're looking for identification, and instead of identifying and also finding the wallet, they find some other type of contraband, then it would automatically be suppressed, that they could not use it?
Your Honor, unless there is an independent basis for that search under the Fourth Amendment, for example, consent, and they could, I would like to return to consent for a moment because I think it might be relevant to this discussion, but unless there's an independent recognized basis under the Fourth Amendment, probable cause, consent, or a warrant, then a search that is not justifiable under the Fourth Amendment would bar admission of that evidence at a subsequent criminal trial. Now, in terms of consent,
so you're not arguing that the police officers per se did anything wrong here, but that their search in an effort to assist who they believe was a victim, anything that they find in the midst of that authorized intrusion into his privacy cannot later, then the fruits of that cannot be used should they find evidence of a crime.
Their benign motive, ostensible benign motive, because I think there was discussion below about what their true purpose was, but putting that to the side for purposes of this argument, their ostensible benign motive in looking for identification does not provide a lawful basis under the Fourth Amendment for the intrusion into the pocket.
Well, now, that goes back to the issue as to whether or not an individual who calls for help or who is being given help and assistance on the street because of an incident, because of an injury, whether that would not constitute consent on that individual's part. And I noticed that there were a couple of cases. There's a case, People v. Quinones, a 1998 case here in the First Department, in a hospital setting, wherein the individual was admitted to the hospital, similar to the facts here, for a gunshot wound. And so they believed him to be a victim, and the medical personnel took off his clothing, and the police secured that clothing, and the police found contraband in the clothing, and the motion to suppress was denied.
That's correct, Your Honor, but the situation in Quinones is distinguishable, and I'm glad you brought it up. For one thing, the issue there was whether the police could take the clothing for further testing where there were certain exigencies established in that case. They thought the defendant was going to die. the defendant never actually challenged the seizure. Well, I want to get to a more important point. The case did not hold that the police could search the clothing. The bullet fell out when the detective was taking the clothing for further testing. So the case does not stand for the proposition, and this is why it's important to distinguish between the seizure of the clothing as evidence of a crime, believing the person may be a victim, and the search of that clothing. Quinones did not approve of the search because no search took place. The bullet fell out accidentally. So the case really does not stand for the proposition that if the police take clothing for further testing, or because they think that it's evidence of a crime, that then authorizes them to go into the pocket, and conduct an actual search. Now my adversary has argued, this is actually not an issue that was preserved below, but my adversary argues, well, because they seized the pants, once they had the pants, they could conduct this, quote unquote, lesser intrusion into the pocket. That is not what the law provides. The law provides one instance when the fact of the seizure would allow the ensuing search, and that's a search incident to arrest, because the greatest intrusion of arrest has already occurred, and therefore, under those circumstances, a search may follow. That is not the case with the seizure of evidence of a crime for further testing, processing, vouchering, whatever the case may be.
Okay, you're gonna have more time on rebuttal because we've run out of time, but I'll give you an extra minute on rebuttal. All right, Mr. Wolcott. I'll get this, Mr. Wolkowitz. Sorry, yes. I said it right the first time. Go ahead.
Yeah, it's totally great. Good afternoon.
Good afternoon.
If I understand counsel's position, counsel's position is against the reason why we have an exclusionary rule. The reason why we have an exclusionary rule is to deter police from doing bad conduct. Even, I know I'm talking on the implied consent. I know Quinones was a probable cause case, but Justice Weber brought up the case Quinones. The language in Quinones says the purpose of the exclusionary rule, and this is the First Department, is hardly served in such circumstances by precluding the police from taking prompt action in good faith to apprehend the assailant.
But Counselor, this is Judge Singh. Isn't the case factually distinguishable of what occurred here?
In Quinones?
Yes.
In some way, yeah. I mean, they're not.
I mean, if the bullet had fallen out, in this case, if the bullet had fallen out, wouldn't you be on stronger grounds as opposed to the cops reaching in there and looking to see what was in the pocket? And even though their motive was completely benign and nobody would dispute that they believed he was hurt and that they should be looking to figure out who he is.
Absolutely, Your Honor. As you're pointing out, obviously there's an extra added element of intrusion here, where they seized the pants there. Here they went into the pants to actually get, the identification for the medical reason. But I'll go back to the language of Quinones. In Quinones, it says, indeed, the urgency and significance of taking immediate possession of the clothing is illustrated by the fact that a spent bullet fell from the jacket. So what the Quinones court was essentially saying was, yes, we need to take this clothing and this evidence right now at that moment, and you could go in there, you could basically search it because things like a bullet could fall out. And that was the point.
Counselor, didn't you have other arguments that you made before the trial court as to why there was probable cause to search the jeans, which the court did not reach?
The court did not explicitly rule on probable cause, Your Honor, but both sides, and again, I'll just go to the language of the court. Defense argues that you'd have to remand it to get that ruling, but I point you to footnote number 2 in Sanders, which says, because the probable cause determination by the court, Your Honor, was the denial of the court was totally permissible, given that both parties argued probable cause. Now, defendant, I'll read you from Sanders. defendant also contends that the appellate division ruling that the search was permissible under the plain view doctrine violates People v. Lafontaine, inasmuch as the plain view exception was not an issue before the hearing court. Here, however, the people invoked the plain view doctrine before the hearing court, and the issue was decided adversely to the defendant when the court denied suppress it. That is essentially saying, how I read that, because it would make no sense otherwise, that the decision of the trial court did not include a plain view finding. So the Court of Appeals is clearly saying that it was okay. They found that there wasn't plain view in that particular case, but it would have been okay to affirm on that ground. And that's essentially what happened here. The defense
wait a minute. Wait. There was nothing in plain view here. They went into his pockets.
Well, no.
They took his pants off and went into his pockets. Okay.
Your Honor, no, I'm sorry, Your Honor. What we're talking about first, I'm sorry, is the taking of the pants. The pockets is the secondary issue. So the taking, and I'm not saying that.
Yes, but the contraband was not visible on the basis of taking off his pants.
I'm not saying that the Sanders ruling by itself satisfies everything here. What I'm trying to say in Sanders is that they ruled that the appellate courts can affirm on a ground that was not explicitly reached by the actual trial court if one of the parties had argued it. I'm arguing.
But aren't there a line of cases, and I hate to say it, I recall being reversed on one of these where we reached it and the Court of Appeals required a remand back to the trial court. Don't you think that would be the appropriate remedy here if we're to agree with the defendant's argument?
No, because I read the Court of Appeals for what they specifically said in footnote number 2 of Sanders. They are saying that if it's
you are quoting, you want us to follow something on the basis of a footnote. It's not even part of the actual analysis in the case.
Well,
okay, we have your arguments, and we are now out of time. Counsel,
I'm sorry, can I have 1 minute to address the implied consent? If anyone has any questions for me about the implied, thank you, Your Honor.
Okay, Ms. Zola, 2 minutes. Unmute yourself.
Just to address this remedy issue that has now been raised, and Justice Singh, that you were addressing, it's just so well established that under People against Lafontaine, this court can't affirm on any other basis other than on a basis that the suppression court did not reach. And the only issue that the suppression court reached on its own, I might add, is the implied consent theory. Now, which we believe the court made an erroneous ruling, and there was no implied consent either on the grounds that he summoned help or anything on this record whatsoever. There's no disputed in verbally consent and expressly consent, no evidence of any nonverbal consent, no evidence that he was even aware the search was taking place. The police didn't say to him, hey, we can't get your name, so we're going to have to, look through your clothes. Nothing like that. So there's the people can't possibly sustain their burden of proving consent. No evidence that he was even aware of the search. So there can't be voluntary consent if you're not even aware that it's going on. So
Ms. Solat, I'm sorry, I don't mean to belabor, but I have a question. If the people never argued implied consent and the defense never argued implied consent, would the court now be precluded from hearing arguments as to implied consent by the people?
The court below?
Yes.
The court below could only hear arguments that had been, if it were remitted, that had been preserved by the parties below, you're correct, before the court. The remaining theories for suppression. Our argument is that actually that there's no need for remittal in this case, because we know the only theory the prosecution set forth, and it provides no justification for the search. I'm going to read directly from the record, if I may, for a few seconds. There was a lot of discussion, a lot of back and forth, but at the ultimate moment, the prosecutor pinpoints what her theory is for the going into the pocket. And she says, and so, Your Honor, at that point, that's consistent with the defendant saying he had been shot. that evidence, the pants themselves would be seized regardless if the defendant was a victim or perpetrator, which was as we have established, may be so. And in terms of going into the pockets, Officer Benvenuto stated he was purely trying to find identification while they waited for EMS to come. So she's stating her theory, which is the pants were seized as evidence of a crime, and then he went in to get the ID. But as I've argued already, the benign motive of going in for the ID is not itself a legal, lawful justification under the Fourth Amendment for the search. It's not probable cause, it's not consent, it's not a warrant. So
But I'm sorry, counsel, the court didn't reach the issue though, right?
The court did not reach that issue.
So then what's good for the goose is good for the gander. No, shouldn't the court be permitted to address the issue? And then if you disagree, then the appellate division will hear it again.
Yes, Your Honor, I understand your position. It does seem both unnecessary and a waste of resources because it is no legal merit, but I understand what Your Honor is saying. I would like to say there are other grounds here for reversal.
Okay, but we don't have any more time to hear them. We will look at your briefs and the record. Thank you so much.
Thank you.
Have a good afternoon. People versus Sidibe.
May it please the court, Joseph Nursey representing Hamza Sidibe. I want to address before the court two issues today. One is the court's erroneous jury charge on justification, and the second is the unauthorized and prejudicial manner in which the translation of the Rikers Island phone call was presented to the jury. This court has dealt frequently with the people versus
on the latter issue. Was there an objection by your by defense on this issue?
There were two objections by defense counsel at the beginning when the prosecution first broached the subject of bringing in the interpreter. The defense attorney stated that he was objecting to it. He said in all manner. And then right before the interpreter actually came on, the court said, and that's over defense objection, correct?
And your client speaks Hausa, doesn't he?
That's correct. Yeah,
and did your client voice any objection to any of the translations since he speaks both Hausa and English and would have understood if there was a mistranslation by the person serving as interpreter?
Okay, when he was being confronted by the district attorney and the district attorney was saying, aren't you talking about bribing the complainant? He said, no, that's not what we're talking about. And he said, if it's going to be translated, translate it correctly. It's on page 183. It says, have him translated. Can you have him interpreted exactly what she said? And he disagreed with every way the prosecution was presenting the statement. And since we're on this second issue, I want to talk about that. Essentially, everything that the prosecution could have done wrong in presenting this translation, it did wrong. First, the prosecutor.
This wasn't a large part of the transcript, though.
It was.
My recollection, it really did not go on and on.
No, you are correct, Your Honor. It's a small part of the transcript, but it was the most.
And does it really go to the heart of the central issue here with respect to the justification?
Yeah, absolutely. Because this was a credibility contest, and the jury had plenty of reason not to believe the complainant. The complainant was drunk. He had a 0.2% blood alcohol level, which is almost.
Yes, but at the end of being drunk, he was also sliced severely in multiple places. He didn't imagine that. That's
correct, Your Honor. And in almost all self-defense cases that this court hears, it's a self-defense. It ends up being a criminal prosecution because the complainant ends up worse than the accused person ends up. That's almost inevitably true in a self-defense case. This was
having been a defense attorney, I can't say that is true, but you go ahead and make your argument.
Okay, this was the critical moment in cross-examination because there's no more significant allegation of consciousness of guilt that a prosecutor could possibly make than to say you're on the phone talking about bribing the complaining witness. And Mr. Siddeby vigorously denied that that's what they were talking about on the phone. And if I go back to the prosecutor comes to court with a tape of a Rikers Island phone call that's not in English, and he doesn't bring what normally happens in this kind of situation, a English language transcript of the recording. And then there is no showing whatsoever of the qualifications of the person the prosecution brings in to do the interpreting. And he's not an official court interpreter. He's brought in by an adverse party. Third, they're playing a recording that's not in English to the jury while they're sitting there, and they don't have a clue what's being said, and that's utterly inappropriate, because when you have a recording in a non-English language, they're supposed to make a transcript, and the transcript is...
Counsel, I understand your arguments, and I certainly don't disagree with the general concepts that you are espousing, but I suggest that with the limited time that you have, that we go back to the issues really at issue. Why don't you get to the justification charge?
Absolutely, Your Honor. In every Velez case that this court reviews, there's not an objection to the charge. That's what ends up making it a Velez case. And in the past couple of months, this court has addressed in two cases Velez error, both in cases that were tried after the Velez decision was issued. One is People versus Herrera, and the other is People versus Melendez. Herrera was reversed, Melendez was affirmed. And when you're looking at something that's being reviewed in the interest of justice, you have to look for distinguishing points in the equities. And I think that one of the big distinguishing points in the equities in those cases is in Melendez and in earlier case of Davis, this court pointed out that there was no reasonable possibility that the person really could have been acquitted on the basis of justification. Here,
why is that not the case
If
here?
I may, I don't see it here. First of all, the defendant even denied causing the injuries, seeing the injuries. He didn't see the bleeding, and we know that the complainant had horrific injuries here.
Okay, when Mr. Siddeby testified, he did not give a videotape replay of how the injuries occurred, but he said he was attacked by a metal object.
Counsel, he not only did not give a recount of what happened, he denied seeing any blood. This man had an artery cut. It was a bloodbath in this market.
Okay,
so if you want to talk about credibility, it seems to me that the jury assessed it.
Okay, but when the jury's that goes back a second, she's being told that they're bribing the witness. But when you look at the credibility of the complainant, one, I mentioned.
Oh, I'm talking about credibility when he says he saw no blood.
Okay. He gave
and also,
his narrative.
He didn't remember what happened. He didn't remember what happened.
Yes. He testified that he was attacked by the complainant with a metal object, that his hands were lacerated. There was evidence presented that he went to the hospital. Mr. Siddeby went to the hospital and had his hands stitched up for the lacerations. He said they got into a struggle over the metal object, and during that struggle, the complainant was injured. He didn't say he stabbed.
And how was he injured, counsel? How was he injured? He denies hitting the victim with the bottle, but the injuries are completely consistent with that. No.
No, I'm not saying they're inconsistent. I'm not saying they're inconsistent with that. I'm saying the only testimony of consistency with the bottle was a leading hypothetical question that the prosecutor asked the doctor, saying, was the wound consistent with being hit with glass?
His carotid artery was cut.
I'm not disputing the injuries at all.
Your client testified that he had no weapon in his hand, and he did not recall having a weapon. And at some point when he was confronted by the assistant district attorney, he said, well, maybe the complainant fell. Maybe, he fell to the ground or something of that nature. There were also injuries of the complainant, which showed that there were foreign objects, I think glass, which was still embedded in his throat or shoulder or what have you, which again would be consistent with having been struck by a glass bottle. And again, your client either denied having any weapon or any glass bottle or anything in his hand, or stated he did not recall, or stated that the complainant fell?
He testified that he was attacked with the metal object. They struggled over the object, and he said at certain points he had control of it, and at certain points he didn't have control of the metal object.
Okay, thank you. You have 2 minutes on rebuttal. Ms. Lewis, we'll hear you. You have 6 minutes.
Thank you, Your Honor. May it please the court. The court's charge here was substantially similar. It's even the same judge as in People v. Dejan Melendez, which Justice Mansonet, you were the presiding justice in. And the court correctly, Judge Carter correctly charged the jury that when explaining the verdict sheet, that if it found the defendant not guilty of attempted murder in the second degree because the people failed to prove beyond a reasonable doubt that the defendant was not justified, then it must find the defendant not guilty of all counts 1 through 4 and mark it not guilty on those counts. And it further instructed the jury, remember, you'll only consider counts 2 through 4 if you found the defendant not guilty for some other reason than that he was justified. That's substantially similar to the charge we have here. And if there are no questions by the court, I'll simply ask for an affirmance.
Thank you. Mr. Nursey, you have 2 minutes.
Yes, in People versus Waugh, they gave essentially the same charge that was given here, that if you find him not guilty on the basis of justification on the greater charge, you are required to acquit on all other charges. That is what the jury was told here. What they were not told was the stop deliberation charge. In fact, it's very strange permutation what happened here, because the top count of attempted murder was being offered in the alternative. The court instructed the jury, if you find him guilty of attempted murder, then stop and don't go any further, but then said if you find him not guilty of attempted murder by reason of justification, then acquit on all other charges, which is the same charge that was given in Waugh. And the judge did not say, as he said, if you find him guilty, stop. He did not say if you find him not guilty,
I'm sorry.
stop.
I just find it so interesting that unless a judge says the magical word stop, that all of a sudden the justification charge is insufficient. I don't understand that. I don't believe that that is in effect what Velez stated, which, as you probably know, I have considered in the past. But I don't think those magical words stop have to be given. And again, it goes back to the point and to the issue as to whether the whole point of this is whether the charge confused the jury and whether there's any possibility that the jury acquitted the defendant of attempted murder and the assault count on the intent to disfigure, whether there was any confusion on the part of the jury as to the justification charge. And I think that, again, that's the issue. And based upon what you've said, I still don't see how you can argue that there was confusion on the part of the jury in terms of the injury sustained by the complainant and his obvious disfigurement.
I'll allow you to answer that. We're out of time, but please answer the question.
The answer is short, that this is the same charge that was given in People versus Waugh, with this court found to be in error, where the court instructed, if you find not guilty on the basis of justification on the greater charge, you are required to acquit on all charges. Yet this court nonetheless reversed because the jury was not told to stop deliberating in Waugh, and that's the same thing that happened here.
Thank you. Hefferman versus New York City Mayor's Office of Housing Recovery Operations. Mr. Welch, you have 6 minutes.
Good afternoon. May it please the court. This case is a perfect illustration of why protection of property rights against the power of the state is among the bedrock principles of the law. In this case, the state acted capriciously and devastated petitioners' lives by depriving them of their right to public benefits conferred upon them by law.
That's right. That's right. Counsel, I probably would not disagree with you, but can you address really the issue at hand? And that's whether or not this proceeding is time barred.
Oh, certainly, Your Honor. That the requirement for beginning a proceeding is that the papers be filed and accepted by the clerk, which they were in this case, according to the statutes and relevant case law.
Well, were they filed?
In valid form. That's the whole issue, was whether or not the petition was in fact in valid form.
Well, the question is whether or not the clerks, I believe the question was whether or not the clerk accepted the petition. And the clerk took all the steps to indicate acceptance of the petition by assigning it an index number, by giving notice that it had received the pleadings. And that's the critical element for commencing a proceeding under Article 78.
Well, so it's not clear to me what date you're talking about. On September 23rd, there was an attempt to file a petition electronically. Is that the date you're referring to?
That's the date I'm referring to, Your Honor.
But was it in valid form at that time?
Well, it doesn't have to be in perfect form, Your Honor. That's
not my question. Is it?
Well, it was in valid form. I beg your pardon. I believe it was in valid form because had it not been, the clerk had the right to reject it. And the statute sets out certain conditions under which the clerk can reject.
But wasn't it rejected, as I recall, because Queens County doesn't file electronically? Wasn't that the basis for the rejection?
No, it was returned for correction.
You had the wrong county. Wasn't it that the wrong county was listed?
That's not the reason it was returned. That was, there was a contractual provision that had to do with filing in New York County. And we did file in Queens County because that's where petitioner.
Mr. Welch, I want to go back.
I think he's frozen. He's frozen. Hold on. Mr. Welch?
Oh, yeah, he's frozen.
Yeah, he's frozen. Mr. Welch? We will wait a moment to see if he gets a signal back. Mr. Welch, if you can hear us, your screen is frozen and you might want to sign off and quickly sign back on so that we can complete this argument. Might I have someone from the court staff please email Mr. Welch and let him know his screen is frozen. I don't know if he can hear me and if he knows what's going on. Advise him to log off and come back on. We will give him a few moments.
Will do.
Thank you. Ms. Fletcher, hang in there with us. Thank you.
Certainly, Your Honor.
Please bear with us. One of our counsel is having technical difficulties.
It's Richard Welch calling in by telephone.
Very good, Mr. Welch. We can hear you. You may proceed. I believe my colleague, Judge Kennedy, was about to ask you a question, okay?
Yeah, Mr. Welch, I'm just unclear
That's fine.
on
Thank
something.
you, Justice Kennedy.
Yeah, I'm just unclear on something because, you know, on page 8 of your reply brief, you acknowledge the fact that the filing was improper because a paper filing was required. But I want to go back. The day that you attempted to file electronically, wasn't that the last day of the limitations period?
Yes, it was, Your Honor. But I would argue both that the filing was timely and proper, and that although I did not put into the facts disinformation, that the filing on that date was not a matter of a lack of diligence on the part of
but that's not the standards.
counsel.
So let's just go back. So will you agree with me that, you know, the case law is quite clear that this type of proceeding is commenced when the clerk of the court actually receives the petition in valid form? Will you agree with that?
I would agree with that up to the, depending on how you define valid form.
Oh, well, listen, well, let's talk about it, because certainly your petition was invalid. It was rejected.
It was returned for correction. In fact, that's the language that was used by the clerk when it was returned to me. I don't believe it's a semantic issue, Your Honor. Probably respectfully, of course.
Okay.
All right. Well, I understand. I think that there are the cases define filing as the delivery of certain litigation papers to the clerk of the court.
I just want to follow up,
the
but the bottom line is that on the
court.
last day of the limitations period, and you acknowledge that, when you attempted to file because it was unauthorized, it was returned. That's a yes or no.
It was not returned that night. It was accepted, and then later it was accepted and given an index number, and later returned for correction with instructions to file it in hard copy instead.
Because that was the rule in Queens County. You may disagree with the rule. You may think that, you know, they should allow electronic filings. I may agree with you on that as well. This was pre-COVID. However, the specific rules in, I think that was September 2019, was that Queens County required paper filings for Article 78 proceedings. This was an Article 78 proceeding. So if we could just move on to your next argument.
I beg your pardon, Your Honor, and I don't want to belabor this beyond the patience of the court.
You literally have 1 minute left, so you can belabor the point or address the other issue. That's up to you.
I will say that I believe there is a difference between a return for correction and rejection, and I think that difference is critical to this question. And I believe that the case law and statute supports that what happened in this case was a return for correction rather than a rejection, and that under those circumstances, under the law, the case is considered filed when received by the court, by the clerk, and noticed as received and assigned an index number. So
you'll have time on rebuttal.
I'm sorry to have.
Not a problem. It happens to the best of us. Ms. Fletcher, you have 6 minutes.
Good afternoon. May it please the court, Kate Fletcher for the respondents. This petition was untimely. The law is clear here. The rules are clear. The petition must be received by the clerk in valid form, and it must be filed in a manner that is authorized by the chief administrative judge. And at the time that this petition was attempted to be filed electronically, that was not a proper way to file a petition in an Article 78 proceeding in Queens County. And my opponent, as the court has pointed out, has already admitted that that was the rule in Queens County. So accordingly, this petition should have been dismissed by Supreme Court as untimely. I it is not necessary, therefore, to reach the merits. However, I would just point out that I think there was a rational basis for the court's position. I'm sorry, pardon my confusion. There was a rational basis for the agency's determination, and under the clear case law in New York, this was not a conscience-shocking penalty. And
Counsel, I'm going to stop you there because
yes, Your Honor.
What happened in this case to this poor homeowner is an outrage. They lose their homes through no fault of their own by a storm that devastated the Northeast. We get federal dollars, and then in administering that, the city chooses which contractors a homeowner should use. They utilized one of your suggested contractors, and they were ripped off. They didn't get what they bargained for. And so it seems quite harsh, okay, on the substance, on the merits, that someone should have to stand by and watch them lose their house, not once, but twice. So if I were you, I would stick to the timing argument, because that is your stronger argument. It's outrageous what was done to this homeowner.
Yes, Your Honor. I will focus on the untimeliness argument. I think that the law is clear in this instance on that matter, and accordingly, there is no basis to reach the petition.
Counselor, how do you respond to your adversary saying that an index number was assigned and so the papers were returned for other reasons? Is that sufficient? Does the assigning of the index number sufficient to trigger the statute of limitations as being?
No, I pardon the interruption, Your Honor. No, an index number in and of itself, purchasing an index number and having an index number assigned is not sufficient to satisfy the statute of limitations, because it is not sufficient to commence an Article 78 proceeding, which requires the actual petition to be received. And under Grant v. Sankowski and Dawson v. Bastine, they have addressed this specific question, whether purchasing an index number alone without successfully filing the required papers will satisfy commencement, and it does not. There was no basis for electronic filing in this instance, and it had to have been authorized, which it was not. And the petitioner then waited more than a month to try to properly file, so it was well past the statute of limitations, which is strictly enforced.
Thank you. Mr. Welch, you have 2 minutes.
Thank you, Your Honor. I would point out two things. One is that this issue was raised below, and it's within the discretion of the trial court under Rule 2004 to extend the time in which papers can be filed. And given that the court rejected this argument below, whether or not the court specifically cited Rule 2004, which does apply even to statutory limitation dates, this issue was decided by the court below, and there's no reason to overturn it at this level. I would also point out that Ms. Fletcher was correct in pointing out that Grant versus Sankowski requires delivery of the papers and purchase of an index number. And I would point out that that case defines filing, the thing that has to go along with the purchase of an index number, as the delivery to the clerk of papers which are stamped by the clerk of the court, who shall file them and maintain a record and assign an index number. And the express statutory language requires a temporal link between the act of filing and the court stamping of the papers. All of those elements occurred in this case. And the fact that the papers were returned for correction, like many of my papers submitted to the first department here were returned for correction, is different than a rejection by the clerk of those papers as insufficient or improperly filed. In
I think there is a distinction between being returned for correction and being rejected. That the rejection is limited to certain specific statutory grounds, none of which were applicable. And given that all the other requirements, including the assignment of an index number, the receipt by the clerk of the papers, the stamping of the receipt, and the notice of the receipt were all met, and that therefore the case was timely commenced under Article 78 without the need to invoke Rule 2004, which in the alternative should be invoked in the interest of justice, and was by the trial court to the degree that the trial court considered the issue.
Thank you so much. This concludes the arguments for the Appellate Division First Department, and it is our last sitting for the calendar month of June. We will resume our regular oral arguments in September after Labor Day. Have a wonderful summer, one and all.
Thank you, Your Honor. You have a good summer too.